Yes. Pass on all the memos. Give.
Congratulations, my lord. Speed, Lord Jagannath, for your good health and your
My lord, this matter is urgent. That's why I'm mentioning, my lord. This matter relates to self-immolation of a female student of Baleswar FM College, Baleswar, my lord.
Yeah.
My lord, today also some political parties are doing agitation, my lord, for his law and order has been disturbed. Humbly I'm praying for tomorrow, my lord.
Yes.
I may be pardoned to make a mention. Your Lordship, this is a from SAPI, OTEPL 42 of 2024. Your Lordship, the identical matter is listed today as item number 24. On the last two occasions also, it was listed together. But however, Your Lordships, this matter could be heard together with that.
Was it listed along with that?
On the same date, last two occasions.
It was listed.
Identical.
It was listed.
Yes, on the on
Then why segregation?
not tagged?
It was not tagged. So
But
this is
it
a fresh matter. You want this matter to be tagged with those matters.
Is the senior leading?
Let us see. Don't worry. If one is decided, it will also decide the fate of this. Don't worry. Pass on the memo.
Read 505 of 2025. I mentioned it last week. It's a matter related to communication of pension.
Let us see. You have pass on the memos. We'll see to it. Don't worry.
Permission, my lord. So, item 24. Your Lordship, I have a question, sir. Legal bid is going to be open today at 11. Your Lordship, I am pleased to notice our special messenger. We have fixed this matter today.
So let us see if we can reach today. Don't worry.
If it says that, Lordship, we will liberty to mention.
Yes.
Adjournment. Item number 52, my lord. I seek adjournment of this item because there is a need of amendment in the petition.
Okay. Just remind, other side is here.
My lord, it's the state.
Who is representing?
52.
It's the AG sir. So if amendment, I need amendment of the petition.
Yes. The counsel for the petitioner prays for a leave to amend the
Please my note for submission, madam.
This is not a, because that was heard by the other bench. So we are simply adjourning this matter so that we'll take up this matter after that bench comes.
Only we have filed our notes.
It's not necessary. File it before the judge, before Justice Raman. Don't worry, take it back. Hello. This matter is substantially heard by a division bench comprising of
In 7/2025, I was given liberty to file an application to add the handling officer and the proprietor for handling the partnership.
Have you taken out an application?
I had filed, my lord, it was listed on 17/7.
Yes.
And by that time, I discovered that the IA number 11,934 of 2025 was filed.
Yes.
That one, it was listed to 2D, madam, to bring that IA.
Where is that IA?
So it has not come.
Why it has not come? It is, if it is filed on 17/7 or prior thereto, then why it will not be brought? Has it been? Is not there in the file? Where it is?
17/7, 11,934.
It is really a sordid state of affair that despite an application having filed on 17/7,
2020.
comma, the same has not been tagged with the file. The concerned department is directed to submit a This is what record that number.
11,934 of 2020.
Item note 4.
Please, Your Lordships.
Yes.
Lordships, the petitioners are retired pensioners of Army, Navy, and Air Force respectively.
Yes.
Due to the excessive recovery of committed amount of pension and in the absence of Army Forces Tribunal bench in Odisha, the petitioner approached this.
But there is another, I think, some other AFT is in charge of this.
Lordship,
There cannot be a vacuum. There must be some other AFT, either in station in Kolkata or somewhere else.
Lordships, the state of Odisha comes under FT bench of Kolkata, and presently that bench is not functioning. And Lordship, as per the Constitution bench judgment in Roger Matthew, it's a South Indian bank.
I understand, depending, that's relying on a L. Chandrakumar's case. It says, talks about a 226 or a 227. It does says 227 will not lie. Have you seen the recent judgment of Justice Chandrachud to 2025 volume 5 SSC? You have not seen it.
Lordship, Justice Chandrachud also ordered for the establishment of armed process. Lordship,
Have you seen the recent judgment of Justice Chandrachud?
No.
Talking about on an issue whether 226 or 227 lies,
No, Lordship.
taking into account L. Chandrakumar and also the this Roger Matthews judgment.
Lordship, on the basis of L. Chandrakumar, the Roger Matthew judgment says under 226 in the absence of tribunal.
Because the second clause of Article 227 excludes the powers to be exercised by the High Court against an order of the AFT. Please read Article 227. Do you have a copy? Clause 2.
Lordship.
Four. Yes, clause 2.
Armed forces come under the.
So then what?
Lordship, for a moment, kindly
So,
There is
so
para
I,
392 of Roger Matthew that says
I am conscious of ubi jas ibi remedium, that doctrine. Yet, if you have a remedy, you cannot expect that your remedy should always be there at the doorstep. If the remedy is at a far-flung place, go and exhaust that remedy there.
that's
I think the
exactly.
Kolkata or whatever, there cannot be a vacuum.
Pardon the lordship, but Roger Matthew exactly says that in the absence of a tribunal in a particular state, the petitioners can invoke the extraordinary jurisdiction under 226. Para 392, your lordship may kindly peruse.
That is what I am thinking. When there is nothing, then if there is some pass given to some armed forces to deal with the cases, then whether it will come. My question is that if there is no tribunal, definitely I understand. But if there is a tribunal, may not be in the state, but in a neighboring state or a nearby state, then we'll have to go and exhaust those remedies.
The lordship, Roger Matthew says if there is no tribunal in a particular state, then the petitioners can.
How does it say? Show us, sir.
Para 392.
Correct.
Read or option. The litigants cannot wait for
Oh,
judicial
that's a
impact
distance.
assessment
Well,
and
built up.
para 392.
Hmm.
And action by the government.
Yes, what I observed, just opposite to that, it is held.
Read, continue.
I'm a very fast reader, don't worry.
Lordships, the central government on the order, even the Supreme Court ordered in 2024 for the establishment of Armed Forces Tribunal. Lordships may kindly peruse the order. And the government is not constituting the tribunal for the state of Odisha. And litigants at this present moment, the bench is not functioning.
No, there are two things. That the Armed Forces Tribunal is not constituted at all in the state of Odisha, or it is constituted, but it is not functional. These are the two different things. I just wanted to know what is the reality.
It's not constituted.
It's never constituted.
Lordships may kindly peruse this order.
We are coming under the jurisdiction of the Kata.
What?
Yes.
Is it functional?
I didn't have that, but it was functional. Now they are saying that this is not functioning. I don't have that knowledge in this.
Lordships, on the basis of Roger Matthew judgment, Indian Ex-Services League approached Honorable Supreme Court for the
I
Constitution.
believe there is one part of the SCC which is lying on my table. Just it's a part 5. Can you bring that?
Para 2 onwards.
I was
may read.
reading yes, last week. I got that. We do not know it. It's not Justice Chandrachud, it's Justice Sanjay Krishna Kaur. That is in case of Parashottam Das.
That is regarding appeal in FT. But this is
Oh,
all-
no, sir, it was relating to the 226 and 227 pass.
Yes, Your Lordship.
It was all the judgment. Paragraph 32. Roser, Matthew, and everything was considered there.
But Roger Matthews specifically says if there is no tribunal,
Oh, that is what is also accepted. There's also a 3-judge bench decision. So serve a notice. Issue a notice. Yes, Mr. DSG.
Yes, my lord.
We are issuing a notice.
Yes, yes.
Returnable after 3 weeks.
Yes, my lord. Yes.
Take instructions.
Yes, my lord.
item
This judgment, this is reported in 2025, volume 5, SCC. The DSG also take note of this.
Yes.
Volume 5 SCC is 786.
Oblige, my lord. I noted it, my.
High Court is-
Sorry, I have not gone through this judgment, but only Roger Madhur
Called,
mentioned.
sir. Let it be called.
Item 5.
Yes, the same thing. Mr. DSG,
Yes, yes, it is the same thing. Yes.
yes, 3 weeks notice.
Yes.
Item number 6.
What happened to you? Why you do not? What?
Documents are required.
At the time of drafting, don't you collect all the documents? How you drafted without the documents? You are in difficulty, say very clearly. Don't put a ground which is unreasonable.
Yes, in this matter, last 3 occasion petitions have been taking time, my lords. And my lords, the work order has already been issued to L2.
There is no difficulty. Is there any interim order?
No, my lord.
Then why you are? There is no difficulty. He asked for a time on the prayer of the counsel for the petitioner, adjourned for 2 weeks. Collect more documents. No, you will be able to collect within a week. Are you sure? Okay.
Item number 7.
And this is the matter relating to removal of enforcement of the land of Lord Jagannathan.
Happened. There is a law, OPLE, or what is that?
Yes, Miller. Steps are already taken, Miller.
Have you
And,
initiated a proceeding against the
yes.
encroachers?
Yes, Miller.
What is the stage of the proceeding?
Miller, eviction notice is issued. As per the eviction notice, they have scheduled eviction to tomorrow, Miller.
For removal?
Yes. Yes,
Should we record your statement?
yes, and for the.
As per the instructions that I have, there are no such steps that have.
That's what he's saying, we are recording. Then your purpose is to remove those encroachers. Purpose is fulfilled. I will be fulfilled. Correct?
And the demolition of the building.
Oh, what will they do? They will utilize the building. Why you are standing in the way of utilization of the building? What?
Detailed instruction from the tahsildar.
Yes. On 7/7/2025, this court directed the Tehsildar to take immediate
This was that excess land, yeah, where the state was supposed to.
look at my order earlier. Huh?
The additional board stand, your lordship, it's a Herculean task. Your
What is a Herculean task?
lordship, get all the land records now. All the departments are concerned. Your lordship may also, it was that the private parties are noticed also, your lordship. So the records also come.
So you have not taken any initiative under Act 1. Now Act 1 has been repealed by virtue of 2013 or 15. What is this Act?
2013, man.
2013 Act. Section 24(2) comes into play. Indoor Development Authorities case of the Supreme Court, there are subsequent decision of the Supreme Courts. Talks about
Vesting of.
the lapsing of the proceedings if you do not take further steps. Now what to do? This land is already utilized.
Kind of, your lordship may also notice the Jindal Steel and Power Limited opposite party number 3, your lordship, and the others, Epicol and Exotic.
There are notice issued.
My lord, notice that my lords had only passed it on a limited ground because my lords had put that question to me and my learned friend had asked for instructions. So if my lords would notice, the other parties will immediately serve them.
For the lordship records.
Because that's the whole problem. No one can give the court a precise answer how much is utilized. And I can tell you, my lords, over 1,000 acres is unutilized. But this is from farmers.
No, the difficulty is, I
Yes,
tell you, once the acquisition proceeding was initiated
my lords.
and it culminated into an order
My lords.
or by passing an award by the collector,
My lords.
then it vests into the government.
Yes, ma'am.
Now you cannot fall back on the score that the purpose for which it has been acquired by the government. Now that purpose is lost. I believe there is a complete shutting down of the doors in this regard. That was available under section 5 or a 5A of the Act 1. Now that doors are closed. If they utilized it or not to utilize it, once it has vested, the divestation can only be done by a statutory provisions, not automatic in that sense. If they have not done, then in that event, the new act has come.
Yes.
That has created a hurdle. Then we can think of what to do.
The opposite party number 3 and also the records can propose how much they utilize, that is the thing. Around 4 to 5 weeks.
How much? This was in the month of June, madam. Now nearly more than a month has elapsed. How long this may be a humongous or a hilarious task, whatever, but authorities have to, because these are the records. The records are lying in your department, traceable one. Well, you know. In whose favor you have settled the land. So you produce the records.
We will produce. But
When?
We will produce. Not in 4 weeks' time.
Another.
June was.
So what? That gives only an impetus to an accumulation of the cases in the docket of the court. Nothing more than that.
Calls and all.
To do good. We are granting them a time for 4 weeks. In the meantime, also, we are issuing a notice upon those private respondents. You affect the service in the meantime. The issue
Yeah. Yes.
Space at what?
Yes, madam. That is not cancelled. Not cancelled.
What?
Not cancelled.
Blood, oh,
Not cancelled. Because he has filed this public interest litigation.
any or he has to institute through his next friend. Is he capable of taking a decision?
Because my lord, since March, no treatment, BMT transplant, bone marrow transplant treatment has been stopped in SCB Medical College. Because non-availability of a trained BMT physician. And the state government is not taking any steps for fresh appointment. For which now more than 32 patients are in queue.
What are you doing?
I have.
If you have a sanction post, if you have a facilities, why you will not? These are all very essential things.
Lordship, may kindly see
Yes.
the subject matter of the present read was
Hmm.
also the subject matter before the coordinate bench
Sumoto,
in Sumoto PIL. The Lordship may kindly see the
it is relating to Katak.
Katak.
Katak SCB Medical College.
The Lordship may kindly see page 2. So far as SCB Medical College is concerned, that has been dealt in page 2 of that order. And this particular BMT, bone marrow transplantation, that is at page 4. The Lordship may kindly see. There was a direction of the, pursuant to the direction of the Honorable Court, the Health Secretary appeared and they have assured the court that already steps have already been taken. And one Dr. Prabodh Kumar Das, who has retired from AIMS.
We are releasing this matter and tagging this matter along with this Sumoto PIL. That page. Because he has already taken note of those facts and the directions are passed. The committee of the judicial discipline demands that there should be a uniformity, not a conflicting
I
orders.
don't have any objection to that. And I request my learned friend to apply copy of the instruction so that I can go through it.
And
apply.
No, these are the orders which are already available on the Sabha. So there is no difficulty. He is relying on an order.
I'll check it.
And my lord would see that instruction, today's instruction. There was a meeting convened under the chairmanship of the Director Medical Education and Training. And it has been committed to start the process from 25/7/2025. They are starting that unit.
The difficulty is trying to visualize. This is such an important thing. It has a lot larger impact on the life and the death, in between a life and death of a person. Bone marrow transplantations is very much necessary in case of.
I have given the list my now applications are in queue. And if you also will verify the medical reports of the present petition while he was getting the treatment, the unhealthy cells are 0. And because of stoppage of the treatment, now the report says that unhealthy cells are increased in his body. Since March, it has been stopped.
Flagging and
Item number 10.
Yes, sir.
Matter Milord, counted. This matter I'm appearing for opposite party number 4. Copy, even though the matter came up on 15th, I received the copy on the 17th of this month. There was hardly one working day in between months. Prepared a very short preliminary copy.
I have given the copy, I'm not contesting, my lord.
No, my learned,
Very
Lordship,
but
I don't think my learned friend would object to permit me to at least file a short count on this matter.
You like to, what is this? They have served you a copy of the additional affidavit?
No,
What?
they have served me a copy of the writ petition.
Yes.
The matter
When,
came, no, on 17th, I'm told, on 17th.
have you already prepared your counter?
I have prepared a preliminary counter.
What is a preliminary counter?
Because there
You have the copy, you know the statement. What preliminary counter?
Because I was trying to answer your lordship's query on the last occasion. Distinct queries your lordship had asked me. So that is what I wanted to answer to your lordship in way of an affidavit.
What was the query raised? My brother was not there. You should apprise him of that.
I'm sorry. I apologize. I apologize.
this petitioner.
Anyhow, it's a preliminary objection, sir. He's not talking on a merit. Don't worry. The moment he touches any merit, I will permit you.
Don't think my learned friend has anything against me to do.
Yes.
Matter relates to the option of a tender of a bus stand.
Bus?
Bus stand.
Oh, bus stand.
The tender was for facilitation, to invite facilitation service experts to man the bus stand. Unfortunately, from 2001 to 2019.
No, you are going into the merit. I just wanted a
very... It has happened. This particular matter was challenged in the year 2019 when the tender was floated. Because there are certain conditions in the tender called notice, which was restrictive and which was suit only to a particular individual, because no one had the capacity to run a bus stand at Ballasur. So such were the conditions. A stay was granted. In 2019, my lords, the matter continued, my lord, till 2021, when the writ petition, my lord, was disposed of as infructuous. During the pendency of this writ petition...
Why it says infructuous?
No, it's because they were initially given 1 year time to collect, my lords, the parking fee. Okay. So since the period of 1 year had already elapsed, the bench thought it proper that it has become infructuous, so they did not interfere. Now, during the pendency of the stay petition, another tender, my lord, in the guise of a new tender, but unfortunately incorporating almost the same condition.
When was stay petition? When the matter is disposed of as infructuous, everything goes.
True, my lord. But while the matter was pending, another tender was floated for the same bus stand.
So that may be a cause for making the writ petition infructuous.
Whatever,
that
sir.
It gives a fresh cause of action.
I'm pleasing the fact of your lordship.
Yes.
That was challenged. While that was pending, the OSRTC, that's the Odisha Road Transport Corporation, they produced, my lord, before the Honorable Court on the date when the matter was taken up, that a work order has been executed. So without going into the merits of the case, the Honorable Court, my lord, they disposed of the writ petition saying that since the work order has already been executed, that we do not interfere. However, the petitioner is given liberty to raise, my lord, its issues in accordance with law.
Right.
So since, my lord, in the tender call notice, there was no grievance redressal mechanism, my lord, we filed an application before the collector, who was the tendering authority. The collector took no action, my lord. Then a second writ petition was filed, my lord. And while in the second writ petition, the collector was directed, that pending the writ petition, the collector was directed to dispose of, because of a particular submission was made by the state that a representation was pending before the collector. So the Honorable Bench, my lord, they directed the collector, my lord, you dispose of the representation of the petition. The petitioner, my lord, of the petitioners, my lord, was disposed of by the collector. The collector, my lord, held that's a non-competitive terms. And since the authorities, the OSRTC, the secretary, my lord, he said that it should be given, my lord, to agency which has the requisite qualification and the experience, my lord. So this particular non-competitive tender should go, and he cancelled the tender. And that particular writ petition, which is the second writ petition, pending before this one. So far as the present petitioner, in the first writ petition is concerned, he was opposite party number 7, in the second writ petition. He was one of the affected parties because he had got the work order. He challenged the order of the collector.
Okay.
On the ground that I was not heard, principles of natural justice was violated, and therefore,
So what query was raised on the last?
query was raised, my lord, whether after the work order was issued, the collector, my lord, had the power to go into the merits of the tender. And so for that reason, my lord, the very tender, my lord, the very tender which was floated had, my lord, as a 3-step mechanism. My lord. First, a letter of a letter of award is after that is accepted, a work order is issued. Ultimately, within 7 days thereafter, an agreement has to be entered into. After the agreement, within 7 days, he has to start his work. So, my lords, my humble contention, my lord, to reply to your lordship's query was that the tender condition itself provided for a clause that unless the agreement is, my lord, entered into, no work can begin. My learned friend from the first writ petition raised a contention. Work order has been issued. I have started working. 2 or 3 bills, my lord, he has annexed, saying that I have presented the bills.
So that does not imply that everything, all formalities which are there have been followed.
No, but your lordship would appreciate that when the tender itself says that the legal, my lord, relationship begins after the agreement is entered into.
True, that is what he says. That
no, but he doesn't, my lord. He says the work order is issued. After
not agreement.
No objection to the work order, the lordship would permit me. I'll place that if the lordship would take up the first petition. Just 3 clauses.
So let them then argue on merit. They are saying.
Your lordship kindly accept my counter.
Yes, this is what is required because this point is.
Well, let me file a counter. Lordship may permit me.
On 25th January 2014, the notice to tender to notice was issued. Briefly taking your lordship proof.
No, I understand. There are the real thing that comes out is the 2 questions. One is that when the tender has already been floated, the declaration has already been made. The work has started. At this juncture, whether the collector can fall back and say that the tender,
that's number 1.
The tender is bad. Secondly, if we go by this, then the tender postulates that there are certain formalities which are required to be done in order to constitute a concluded contract. For the purpose of a concluded contract, what he says is that first step is the LOA, the second step is the work order, and the third step is an agreement. Then it constitutes a concluded contract for the purpose of enforcement, or you can take shelter. So according to him, it cannot be done. These are the two questions we'll have to answer. If I correctly understand,
I'm only answering. There is a third situation I'm bringing in here. Third is the person who has never participated in the bid questions the conditions of the bid after the award of for the first time before this honorable court was filing writ application after the work order was issued.
The question is, suppose if the conditions are so harsh and so onerous that it deprives many people and only to suit certain people.
He says that
does it not offend Article 14 and this?
I understand what your lordship say, but he in his own say that I didn't knew about floating of tender. Once I wake up and then the rush to.
So let them file their counter. You just go through the counters. We will hear out the matter. There is no difficulty.
This honorable court has rejected this prayer. Rejected the prayer.
No.
And I'm just
show us that where it is rejected.
Yes, ma'am.
Where it is rejected.
Yes, ma'am.
That this contention has been absolutely overruled.
It has not been considered at all because of the work order.
No, just have a patience. Have a patience. Let him.
Paragraph page 119.
119. Okay.
That's it. Kindly have. The prayer is quoted in the order.
Correct.
The petitioner in this particular has prayed for the following.
We find from the annexures, if you go there. I think annexure.
Prayer is quoted, my lord.
Yes, they wanted issued by the such and such under the annexure, direct
now
or fresh tender, deleting PQ3 to
Yes, but
7
Now,
and PQ13.
Lordship on to paragraph 4 of the order.
Mr. Bose means who is for
Paragraph 4 is for the petitioner counsel. Mr. Tripathi on an additional government advocate and Mr. Rathod on a counsel for the opposite party number 7 submits. In the meantime, work order pursuant to Annexure 7 has already been issued by the collector Baleswar on 11 February 2025. In view of the above, nothing remains to be adjudicated in the writ application. So the prayer has been refused. And now your lordship kindly have at page 94 is the work order. Whether it is concluded contract or not, I am just showing your lordship. And at paragraph 6, my lord, it may redress the same in accordance with law. Now the second writ application is filed, that also I have annexed, my lord, exactly the same prayer with a twisted statement of facts. My lord, page past this twisted statement I am showing you, lordship, at page 139, paragraph 19, that's the twisted statement. Paragraph 19, 139 page, yes. Paragraph 19, I'm just reading it. Let's make kindly have. This is 130 now. 139 I'm reading, my lords, because but the petitioner could not challenge the work order as it was recently granted to the petitioner and did not have the access to the same. The writ petition was disposed of by order dated 24th February 2020.
Which one you are reading? Now I am at page 138 and 139.
139, my lord.
Which portion?
Starting with the
Second line.
second line. What? Yes, my lord. But the petitioner could not challenge the work order as it was recently granted and the petitioner did not have access to the same. The aforesaid writ petition was disposed of by order dated 24th February 2025, holding that since the work order has been issued in pursuance to the tender notice, nothing remained to be adjudicated. The Honorable Court was pleased to grant liberty to the petitioner and the petitioner in case any further grievance, the same may be redressed. Lordship, kindly mark, they have stated here any further grievance. The annexed document is the original tender condition again. And the prayer in this writ application. That's why I am saying it's a twisted statement. And please, my lord, at page 143 is the prayer. The prayer I have shown in that order at page 119, and now the prayer. Here, my lord, that can be the second writ application, they are fine. So
So maybe, so they wanted, now the collector has cancelled it.
Well, a collector cancellation is
And your
one
lordship
thing.
would- your
The
lordship would
second
see the
part
reason.
That's the main thing. Now
This
you are
second-
challenging that order.
Page
that is
25, your lordship may
my-
kindly see the
second
reason
part
of the
is-
collector. Ma'am.
Oh, whatever is, now the collector has challenged, has set aside the tender. Now what? So you are challenging that order, what do you want?
My case is that the once there is I am just drawing the work order because that's your lordship has asked.
Sir?
Page 94. One,
There are-
lordship
there are-
kindly have at page 94 for a moment. Before I elaborate. Page 94.
94.
Yes, my lord, that's the work order.
Yes.
And I'm just reading the last sentence. With the terms and conditions stipulated in RFP, you are hereby directed to deploy your resources at Ammo bus stand, Sahadev Kunta, Baleswar. The scope of the work and the number of personnel deployed are be altered, modified as per the requirement during the engagement period. The work order shall remain in force for a period of 5 years only. Now there is a chart and everything. So the terms and conditions already embodied here. So the stages is clear, my lord. Once I evolve as L1, then LOI was issued. I deposited my security, then letter of award and was issued.
Sir, the question, whether first thing, whether the collector have exceeded his power or the jurisdiction in declaring that particular tender to be not in consonance with the constitutional provisions.
Question here is, my lord,
You are
Can-
challenging an order of the collector here in the resolution on the premise that the collector could not have ventured to go into it.
yes, ma'am. Yes, ma'am.
We just wanted to know because all these orders are there. Work order, the release, everything was there. Now what do you want to say?
I want to say it could be terminated because the contract is now in place. The only situation
What?
terminated, then the termination could have resulted in damages. I can ensure
There
that
is an order conferring the jurisdiction upon the collector to take a decision. Is there any?
there is no
order.
there is
That's a line,
Your
last
lordship-
line.
your lordship
For the grievance you can approach.
Yes,
That is the only ground.
that's the only room. There is absolutely neither the tender condition stays nor the
So we let them give a preliminary counter. We want to know. Here, you just peruse it and give an answer on Monday. Give an answer on Monday. It is granted to the opposite party member.
My lords, this is a
Happened in the Bhubaneswar Unnayan Parishad.
may I submit? my lord?
Yes, what has happened to the Bhubaneswar Unnayan Parishad?
Yes, my lords. Milord, this is a actually this is a writ petition in public interest litigation in which we are seeking a proper landfill site in Bhubaneswar or somewhere in the outskirts of the city instead of the present one, because the present Garkon site has been operating since 2008 without there being environmental clearance, without there being authorization under the municipal solid waste rule, and even the consent to operate. For a second, your lordship, can I take your lordship's attention to page 30, PDF page number 30?
Writ petition.
Yes, yes, it's public interest litigation. Yes, page. This is ground 7. That's my prayer, Mr. As I said.
Page?
Page 30, PDF. The running page number should be 14.
I am unable to find out. Okay, find out.
Page
Page 14.
Page 14, 1-4. And PDF page is 30, 30.
Got that. Page 14, actually running page. It is 30 or 7 or 9.
This is in respect of annexure P7, my lord.
16 years.
Yes.
Yes.
Can I read, my lord?
Yes.
Yes. 16 years after starting the landfill site at Gadakona, the Bhubaneswar Municipal Corporation on 23rd February 2024 applied and was granted consent to establish the integrated processing facility for management of municipal solid waste at transfer and treatment station at Gadakona for processing municipal solid waste 40 metric ton for window composting, 15 metric ton for micro composting, and material recovery facility at a capacity of 1.87 metric tons.
Yes.
The consent to establish was issued by the regional officer, State Pollution Control Board on 25th February 2024. Makes it clear that the Bhubaneswar Municipal Corporation so far didn't have environmental clearance, doesn't have environmental clearance, which is given by the state level Environment Impact Assessment Authority following appraisal report from the State Environmental Appraisal Committee. Clause 3 of the memorandum of that consent to establish, I have quoted here, it reads, the industry is to apply for consent to operate under section 25, 26 of the Water Act and 21 of the Air Act at least 3 months before the commercial production and obtain consent to operate. As of now, they do not have consent to operate, my lord. Clause 4 of the memorandum for consent to establish reads, this consent to establish is subject to statutory and other clearance from the government of Orissa and or government of India as and when applicable. As for the notification of 2006 of the government of India, the municipal corporation ought to have taken the environmental clearance under the SEIAA. If no consent to operate has been taken, the landfill site could not have commenced collection of garbage as it has got a huge pollution potential, and the government of Orissa represented through its secretary, chief secretary, principal secretary, Department of Housing and Urban Development, principal secretary, Department of Forest and Environment, Climate, and Odisha State Pollution Control Board, Central Pollution Control Board, the Commissioner Bhubaneswar Municipal Corporation, and Collector cum District Magistrate Khordha are the officials responsible for this illegal operation of the landfill site without there being consent to operate since 2000.
He is flagging an issue of environmental hazards.
Yes.
The composting and then accumulations or
That's fine. All these things should be done. I say,
those
my lord, my submission is all these things should be done in accordance with a rule. You cannot just throw the garbage in a city just adjacent to Sainik School and it is surrounded by Utkal University and many other colonies.
Oh.
That's the basic question. And recently, my lord, they have also, sorry.
Out of 11 opposite parties, I stand for the opposite party number 16.
Sir, you are one of the stakeholders. You are one of the responsible person. You are.
Preliminary objection I do have.
What preliminary?
Earlier, this is a second round of litigation.
Yes.
Earlier, my lord was disposed of.
What?
And my lord, can you have a glance to the last annexure? That
it was withdrawn without any limit. Now, can I have a glance to that? Order dated 26/6/25.
Yes.
In earlier repetition, similar same party between the similar method, almost similar play, and my lord directed for it was disposed of as withdrawn.
Because they want to withdraw, it was permitted to be withdrawn.
Man.
Then-
But no liberty was granted. Number one.
So
Now,
one thing is,
number two,
can there be an res judicata in respect of a violation of a fundamental rights of the citizens? These are the fundamental right to life includes a right to healthy life in a healthy environment.
Now, my lord, may I
Can you
request
come?
the second objection, all these matters,
Healthy environment.
my lord, all these matters were disposed of in the Green Tribunal Principal Bench at Delhi, taking the entire nation and directions were given. And thereafter, the Eastern Zone was also constituted. Now, the entire matter that the, before my lord is, was also taken up by the Eastern Zone, and that is also disposed of by the Green Tribunal only in order dated.
Where is the order of the Green Tribunal?
My lord, may I interject, my lord, for a second?
And
This order, just a second.
dated.
Just let us see.
My
Yes.
lord, can I just
Wait, Mr. Counsel, wait. Have patience. Yes. Yes. What do you say?
Yes, my lords. These are the three.
No, not you.
Okay,
Not you, the municipal corporation.
my apology, my apology.
Yes, what do you say, sir?
Directs that were given are being followed, and the consent is taken. Now, the question with regard to the landfill is not a landfill; it is a processing unit. It is a process. The garbage is not collected.
Sir, then you'll have
Yes, temporarily right.
sir, when you say that the nature of the land, what he claimed is not correct, then you'll have to bring those materials before this court in the form of an affidavit. You say that it is not a landfill.
Not landfill.
Correct. It is something, a unit or a processing unit which is set up there.
Consent by the SPC.
Correct. Now, the processing unit is being operated at a particular place where all the surrounding citizenaries or the inhabitants, they felt that it is the health hazardous because of the emission of the various obnoxious gas that may come out because of the accumulation of the garbage. I think when you accumulate the garbage, sometimes it emits the methane gas, which is not very conducive for the health, which is not very good for the health. All these, what steps you have taken to combat or to prevent those kind of emission to come? These are the things you'll have to disclose. They say that there are certain rules. Environmental clearance is one of the important facets. You say that the approach was already made to a Green Tribunal. The Green Tribunal has taken stock of the entire things and have passed certain directions which you are complying. You just show, disclose, is a PIL. It's not an adversarial litigation, sir. Everybody is responsible for that. You just file your affidavits indicating all those facts and the steps which you have taken. Madam, you are the state?
Your Lordship, for OP number 1.3.
Yes.
We are for the OP number 8 and 9.
Against the SPC board, State Pollution Control Board, he has also brought allegations against them. That they also answered because they have also.
Sir, these are all the integral part of the entire system. So they are there. Somebody is representing the Pollution Control Board. You are.
No, Your Lordship.
Why there will be another set of lawyers for the board?
Yes, notice should go for Pollution Control Board or the Central Pollution Board.
They are the part of you. You have set up the Pollution Control Board.
Corporations and such bodies, Your Lordship, they have.
They are instrumentalities of the state. Why you are?
But very interesting.
You know the fate of it. Who represents normally?
Mr. Santi Mohanty. Santi Bhushan Mohanty. Santi.
Can you bring him so that at least we can expedite the matter, because this is of a very great importance, what we perceived. Can you bring him? Do you know him?
Yes, yes.
This Mr. Santi Mohanty?
Yes, we know some advocates are there in the panel.
Yes.
I can, if your office calls after the
Anybody can.
debate.
So instead of giving a notice that will delay the process, if he comes, we can direct him to accept the notice.
Vibhu Das.
Whoever, we don't know the name.
2-3%.
2-3% by anyone.
Oh, you have given a notice? I don't think so. No,
No, it's not.
not given.
Time. Yes,
This is the first time it is appeared. This is the first time.
First time.
Interestingly, these
Call him
Sainiks.
over the telephone
Yes.
to appear at 1.
Maybe tomorrow or day after tomorrow, so that any it will be convenient to manage.
If he is present in the court, we want everything to be expedited. We'll give you opportunity to file your affidavit, don't worry.
Yes.
But in his presence, so that he will also file an affidavit.
Madam.
So bring it.
Submit me not. Serve that copy on me, so that.
You have not been served with a copy of the writ.
From download, they are half of the.
No, my lords, all parties have been served.
Legible.
Yes, my lord, that is your.
What are you talking about? I think the copy is legible.
What should be there?
You must have a defective printer.
And it
Printer.
because the photograph that here, I just saw my lord.
State pollution.
Not understandable what they have.
Can you give a copy? Can you give a hard copy to them?
Yes, my lord. My colleague is there. Actually, my lord, I am making submission from Delhi.
Yes,
My colleague is there
you
and
have the extra copy.
He will give the copy.
He has some difficulty from in downloading from the server.
No issue, my lord.
You have the extra copy.
My colleague will give there.
My lord, advocate for the Pollution Control Board, he has been informed, he is coming.
So just a passover for the timing. We'll direct you to serve the copy, hard copy. Let him come. If he comes, just remind us.
Milords, my one more thing, Milords, may I be my colleague will be appearing, Milord.
Don't worry, sir. We'll pass a direction for affidavits. Don't worry.
Yes, ma'am.
Yes, you can go and attend some other case. Don't worry.
My lord, I'm so.
Your name would be recorded. For item number
12.
Item 53 on your lordship's board. Remember, this is the research matter regarding the definition of tender.
Yes.
Lordship, on the last occasion in the connected matter, item 53, your lordship has submitted that I have to include the successful bidder in the as a party.
Because he is a necessary and proper party. Because he will be affected by this order.
Lordship, I have done that. I am filing the affidavit of service in this regard.
You have served?
Served, your lordship. Served through email as well as through requisites.
Somebody was mentioning in the morning, item number 53 to be taken up, I think.
But I have not made
Whatever.
petitioner.
Not 53. 53, I have a gut feeling. Okay. So nobody, where is the service?
Now that's changed.
Where is the postal receipt of the speed post?
Belongs at page 74.
53. And where is the track report?
Not next to track report.
You have to.
But that's been Lordship, one.
Sir, sending a petition is one thing, but service of the petition is another. So we have to ensure that the service is affected upon him.
Lordship, they have page 5, the email ID of the petition of the successful bidder is reflected in page 5, and on page 6, I have served them via email also. At page 5, right-hand side bottom here also, email.
No, I've seen, but that email appears to be of any company or what?
Lordship, the proprietorship concern.
Jingle. She's married or what? She's writing in the Baroda. She must have been married. What Jingle? What is the challenge?
Lordship, the challenge is with regard to the rejection of my bid.
On in a technical stage or a financial?
Technical.
Why?
Lordship, what they say is that I have not submitted the documents. Your Lordship may have page 92.
92.
Lordship.
Yes.
Lordship, that's serial number 2.
Yes.
Sanjay Kumar Agarwal, A-class contractor, as per Annexure 1, Schedule 3, Clause 7 and Clause 112E of DTC.
Clause 7 and Clause 112E.
Of the DTC.
I think there was one matter which I have taken up on the same ground.
Yes, Lordship, the connected.
53.
Yes.
And I think the order was passed there.
Lordship, the order was.
What is that order passed? So it was only implement, nothing more than that.
Your Lordships have orally directed not to proceed with the finalization of the tender.
Yes.
Only the LOA has been issued and the agreement was not executed in the meanwhile.
Yes.
Yeah, similarly, in these 3 matters, in item number 12 also, LOA has been issued members. I may be permitted to give the copy of the LOA to the petitioner counsel to be increased in similar manner as item.
Whatever, madam, I think clause 7, where is the clause 7 and clause, if I correctly remember,
Page
there
40.
is page
Page 40.
40.
40.
Okay.
The DTC starts at page 40. The clause 7 is at page 41, the top of the page.
Huh? 41, huh? Yes. Yes, clause 7.
If may I read? The civil contractor, in order to take part in the composite tender, should enter into an MOU with eligible registered electrical contractor having valid HD LT license for execution of electrical installation and other electrical works, and a copy of such MOU should be attached with the tender as per the Proforma Schedule J, which shall form a part of tender. A copy of electrical license should also be enclosed with the tender paper in the original of which need to be furnished during verification. The above MOU is not required
So
in case
this
of
should enter into an MOU with eligible registered electrical contractor
Lordship.
having a valid ST and LT license.
Lordship.
You have to show that you have entered into an MOU.
Lordship. May have page 95.
Page 95.
Let me see. The first party is the petitioner, here Sanjay Kumar Agarwal, and the second party is Mr. Shivani Infrastructure at 95.
Why? Okay. Yes.
Lordship.
So first party is you and the second party is Shivani Infrastructures. They are the licensed, the electrical.
License is at page 143 of the resolution.
License is
At page 143.
143.
Not.
Yes.
Lordship. This is the electrical license to whom?
Contractor's name is Shivani Infrastructure and Suppliers.
Lordship. The personal details, contractor name Shivani Infrastructure and Supplier, proprietor Yeshwar.
Yes.
Lordship. I submitted the same. I have submitted this particular document in my bid documents. Your Lordship.
What is this to 112E?
Lordship, this is with regard.
You're
to
talking
ownership of
about clause 7. And they have also used the clause 112E.
12E. Yes, sir.
Where is that?
Lordship, that is at page 50.
58. Yes.
Lordship. Clause E, evidence of ownership of machinery or equipments as per
Correct.
clause.
So where is that evidence?
Lordship. The clause, the schedule C is at page 84. And your Lordship, the list of machineries, if your Lordship can kindly have page 101.
Page?
101, your Lordship.
Yes. Concrete mixtures.
Machine. Yes, your Lordship. These are all the machineries which were required as per the schedule C that has been submitted in my bid document, your Lordship. And that
Yes.
has already been annexed. So part of the writ petition, your Lordship.
Yes.
Now, the requirement for concrete mixture machine in the present tender is 1 number, whereas I have submitted it as 6 number of concrete mixture machine Lordships.
Okay.
Lordship. Then the second thing is concrete plate vibrator. The requirement is 2 number, your Lordship. I have submitted 2 numbers. Lordship may have
Yes.
page 102.
Yes.
And then page 123, your Lordship.
What is that?
The same concrete vibrator, your Lordship.
Okay. So these are according to Schedule C.
According to schedule C.
Yes. So you submitted.
Yes, Lordship.
Have you taken whether they have submitted those documents or they have filed for the purpose of the writ?
That's in item number 53, my lords. We have filed a preliminary counter affidavit explaining why his bid was rejected, my lord.
That is 53 relates to him.
Yes, my lord.
Lordship.
Same
It's
petition.
all arising out of one particular tender and the petitioner is same. In both item 12 and 15.
And in that also the same ground.
Same ground.
Clause 7 and
Identical.
112E.
100.
Yes. What do you have said?
My lords, in the said affidavit, 2 things are mentioned, my lord.
Hey, 53. It's fine now. Yes. Where is the counter?
Preliminary counter affidavit, my lords, filed on
Yes.
17th July, my lords.
Yes.
If I can bring it has been served to me today morning itself. Your Lordship.
Let us see first. If I find any substance, I will definitely permit you. If we do not find any substance, then unnecessarily what you will do?
Lordship. Lordship, they have made certain observation in that and to take into
Let us see that, yes, madam, show us.
Para 5.
Hey, 53. Yes, I am at
Para 5, my lord.
paragraph 5.
My lord, in the rejection order, there was the reference to annexure 1 as well, my lord.
Yes, no, paragraph 5, you are saying that the technical bid was opened on 23/4.
Yes, my lord.
Technical evaluation committee meeting, it was held on 16/6.
Yes, my lord.
You have rejected his
My lord,
detailed deliberation, failed to secure the minimum requirement of 80 marks.
this was the reason for rejection, my lord.
Now, 80 marks, now you are saying clause 6 and
Yes,
clause,
Yes,
you have shown clause 7. Can you prevaricate your stand? In the affidavit, when you have shown something else in your rejection order?
I may again refer to the rejection order, my lord.
it talks about clause 7 and 112E.
Also, my lords, annexure 1 and schedule 3, my lords.
Where is that? Show us.
In item number 53, my lords,
Yes.
petition number 18797 of 2000.
700?
This petition 18797,
Yes, we are having that.
page number 92, my lords.
Page 92.
Yes, ma'am.
Yes.
As per annexure 1, schedule C, clause 7, my lords.
Was
Yes, my lords. Now, my lords.
clause 7 you have referred.
Yes, my lord. That in the affidavit we have mentioned, my lord, it is inadvertently.
Sir, madam, very, very simple thing. You have said two bidders were disqualified. The first bidder is he, where you have said as per annexure 1, clause C, clause 7 and clause 112E. Now, what is this annexure 1 or I do not know.
It
What is that annexure I? Show us annexure 1,
82, my lord.
82. Plus. Yes.
My lord.
What it says, list of the plants and equipments to be deployed on a contract work. Yes, number of machines required, complete mixture 1, concrete vibrator 2, concrete vibrator needle type 2, water tank 1. All these things have been given.
Against that, a mark is specified, my lord.
Correct.
And refer to para 6 of my affidavit, my lord.
Yes. Yes, you have said that he does not, let us go by this, that he does not have the valid truck tipper,
Yes,
2 numbers, correct?
yes.
And
Accordingly,
then,
some marks have been given in that description.
so 10 marks was there,
Yes, sir.
so no difficulty. Then
And then my second point,
what he does not have, show us, only one.
second point, my notes, serial number 2, staging, shuttering and centering arrangement, section of plants and equipment, the bidder had uploaded.
Now, please go slowly, one by one.
Yes, ma'am.
So as per annexure 1, he does not have that truck or a tipper.
Yes, ma'am.
True, that is what paragraph 6 says.
Yes, ma'am.
So this is one ground.
Second,
Second,
at page number 4, Roman 2 minutes.
page number 4.
Roman
Yes.
2 minutes.
Yes.
Further in staging, that is serial number 8 at page number 82, my lord.
Yes. Where is the call? These are required.
Yes, my lord. Page number 80, serial number 8.
8.
Yes, my lord.
Complete staging, shuttering, and the centering arrangement.
Number 500 SQM and mark is 20 marks. Here he had not submitted 500 SQM material. Staging do not bear any units against the required 500 SQM staging material.
Correct.
And hence 20 marks has been deducted, my lord.
Yes.
And if I here in total he received 70 out of 100 marks.
But you have indicated 80.
80 and
80 is a qualifying mark.
80 is a
The qualified. Okay.
as per clause 6, my lord.
Now, I will consider. So according to you, 20 and 10,
Yes, ma'am.
30 marks he could not. He secured 70 marks. Noted. Qualifying marks is 80. What is this clause 6?
Clause 6, and refer to page number 40, my lord.
Yes.
Roman 1, 6, Roman 1, the contractors.
80% marks.
Yes.
That only talks about 80% marks.
Yes, ma'am. As per Annex 1,
or an annexure as in Schedule C.
Yes, ma'am.
So this is annexure 1, Schedule C. Yes. Now, no difficulty. That's the only ground.
Yes, ma'am.
Show us that you are intact. You have given.
Lordships may
Just show us that you have given a document
Lordships may kindly have page 116.
of 50, item number 53. 11?
116.
Yes. Yes.
You'll see there are two invoices.
Yes.
Lordships, the item are shuttering plate. The quantity has been mentioned, irrespective of the
500 kg.
500 kg, irrespective of the square meter that has been prescribed in the present tender.
Yes.
But your Lordship may kindly have page 96.
Yes.
Lordship, this is a certificate by one of the authority, the state government authority, under whom I work as a contractor, and
Yes.
they have certified that I possess 1000 square meter of these steel centering and shuttering plates.
Yes.
These are all based on my prior experience. The Lordship may kindly also have page 97.
Yes.
Lordship, it is the same department, so who is the tendering authority, has given me a certificate on 3rd of July 2024, stating that I have 2000 square meter of steel.
What was the last date of submission of the application?
of 22nd of April.
22nd
of April 2025.
2020. Okay. Yes.
So it is the
So these documents were submitted.
This was submitted.
These documents are submitted.
Submitted. What about the truck order tipper?
Truck tipper, it has been submitted to the Lordship in their additional affidavit. What they have taken a new ground is that in some cases there was no insurance, and in some cases there were.
So at least the 10 marks can be deducted
10
from
marks
there.
can be deducted, Your Lordship. If 70.
So then you secure 90.
It comes to 90, Your Lordship.
So you are eligible.
Yes, and also in the page number 26, what they have submitted in additional affidavit.
If you cannot deny that those documents were not submitted, then in that event, your own department has given a certificate of staging the shuttering and the centering arrangements up to 2000 square meter. Then what more? You want a 500 square meter. Don't go for a cherry picking. Don't go for a cherry picking. I can use this term because the Supreme Court in one of the judgment has used that term. There is no difficulty. But this is absolutely, may I use the term, unbecoming of authority. No. What is the stage when the financial bid is going to open?
What if the financial bid has been opened?
No, we are directing you to open your bid.
LOA has been issued in the.
We are cancelling everything.
Executed in the meanwhile.
Have you challenged that LOA is also there?
Not.
LOA has already challenged in the procedure.
I just wanted to know from him. Sure.
Lordships may kindly see my prayers at page 30.
30 in 53 or present one?
53,
It's page
page 30.
30
13.
13.
Lordship.
Okay. Yes.
Lordship, I've asked, the prayer is admit the petition beside the rejection of bid of the petitioner dated.
Correct. That is what you say.
Lordship,
Then-
then the LOA was issued subsequent to the filing of the writ petitions. It
Well-
was issued on 30th of June and the writ petitions were filed on 26th of June, Lordship.
The party in whose favor it is issued, have you implemented him?
Lordship, in 53 I've implemented, other I don't have the whereabouts, your Lordship.
No. It is in relation to a same
Same tender, but different works.
different works.
Yeah.
And it is awarded to the same person?
Lordship,
LOA?
one more tender has been awarded to the same person and two other has been awarded to two different persons.
In 53, you have implemented,
50,
you have
yes.
served, they have not come. But so far as
I
the
don't have instruction as to who are the parties, your Lordship.
My lord, I will provide my lord.
provide. In 53, we are granting a stay of the LOA not to exist.
documents were there in the document. Your Lordship.
But they have to corroborate it. They corroborated in that matter.
I've brought on to that observation.
You implead them, serve a notice. We are fixing this matter on next Monday.
Lordship, this is that your Lordship also kindly did that no agreement to be executed.
No.
That Lordship, as Lordship may kindly have this week, your Lordship. I'll include them today, your Lordship.
Today, implead them and serve the notice.
Lordship.
It appears that that during the pendency of the writ petition, the LOA has already been issued in favor of a third party. Stop. The state is directed to disclose the name of the person in whose favor the LOA is issued, so that the petitioner may implead them as a party. The liberty is granted to the petitioner to implead those persons as
Yeah, Mr. Das is there.
Four
Yes.
matters be tagged together and be taken up on the next. Yes, he has come. Sir, there is a serious things which has to be noticed. So you are for the pollution control board. So why don't you accept a notice? Waive the service of notice, accept the copy and then appear. Oh, who is for the petitioner?
I am on behalf of Mr. M.R.PATHAK, the petitioner.
Now you have come. Somebody, you are a junior.
Yes, yes.
Yes, you appear. You serve the copy in course of this day or tomorrow?
Yes. In course of the day, we'll serve it.
No, somebody says in course of the day, you say by tomorrow, what to do, sir?
We are now making it
The instant petition in the nature of a PIL raises a very serious issues with to violate your norms.
I'll definitely
Take instructions.
Instead of 28, madam, first week of August.
August.
4 days.
Yes. What do you say?
First week of
First week of August. Do it.
It will be 4th August.
4th August. Do it on 4th August. Let's call the next.
Item 13.
May it please, my lord. I'm appearing virtually, my lords. My lords, herein in this case, as per the last order, my lords, the learned state counsel was to file an affidavit. She has done so, my lords, in today, my lords. I've received the copy. I just seek an adjournment in order to take necessary instructions in that regard, my lords.
Would you like to file rejoinder, madam?
My lords.
Yes?
Yes, my lords.
How much time you require?
My lords may call this matter after a week or so.
It is submitted by Miss Ayushi Mehta. What is the matter about, sir?
Missing of the
Minor victim girl. What has happened, sir?
And the investigation and progress in that substantial.
Have you got the whereabout?
Yes.
Yeah?
and legally constrained to utilize the liberty your lordship had granted me today morning. That item number 54, the tender matter, where the bid opening was there, scheduled in 54 weeks ago. It was 53 then. 53. Okay. Just wait. What has happened is in the meantime, since the bid opening was there today, state has entered appearance in that year. That day they didn't accept notice. Notice was sent by a special messenger. Now, despite knowing that the matter is on your lordship's board, the opening of the bid was there today. They have proceeded with that matter on the ground that there is no stay in it, despite the fact that they have taken notice on both the I and the writ application. Lordship may take it up anytime, but at least in the meantime, Mr. Carr commented advocate is appealing.
Call him. Take up. Before we rise.
My lords.
Item 15.
Please, my lords. Item number 15, minor girl minutes. While is going to a computer class, she has went missing.
The incident he has been, yes, last night he has been detained in the police.
This ex parte order passed by the department, and the advocate who appeared in this case had died before. Similar order passed by your lordship also.
Where is my own? This is the petitioner case. That is the petitioner already on another.
When he died,
July,
when the date was
44, madam.
when the date was 6.
Before that, he was, my lord, under treatment, my lord. That is July 24th, 7 minus.
Yes.
Fix a date.
Decide it up, right? Next 2 weeks.
Item 20.
I think this matter, my lords, we should challenge this the first appeal order in this government.
Governor.
Yes, none. Yes.
Deposit 10%. That's a statutory obligation. Yes.
21.
There is a very recent judgment on that. It says that we are 36 does not mean it will dispense with the statutory requirement.
Yes.
21 was also similar regarding non-constitution of appellate tribunal.
10%.
Yes, sir.
Item 22.
22, your lordship, is RC cancellation.
Listen,
Item number 22, Mr. Prithak should appear in this case. It's next in another court related to my pass over. Questions raised in this.
Is like a appeal before the High Court.
Yes, ma'am.
On a substantial question of law.
Yes. Madam, the question of law now stands answered by the jurisdiction of that. In another matter. Earlier, madam, the same issue came up in another appeal, customs appeal. This identical question came up for consideration, and this honorable court was pleased to dismiss the appeal of the revenue.
We need to representing you to that.
Yes, that is always there. That is always there.
There is a senior.
Sir, he's in court number 16. He's in court number 16. His matter is going on. We wait.
Item note 25.
Thus, here the order of the Honorable Single Judge is under challenge loss. The petitioner who has lost relieved from service on voluntary retirement in the year 2003 loss. And he approached this honorable court for not payment of his dues along with the interest loss. And he approached loss in the year 2013.
This your application for voluntary retirement was accepted by the government.
Yes.
And after accepting, they did not pay you a single pardon.
No.
That not.
No. That was paid in 2018 loss. So I had filed a writ application in 2013 saying that since 2013 I have not been at 2003 I have not been paid my amount. So let them pay the amount along with the interest loss. And matter was adjudicated loss, and similar matters went to the Honorable Supreme Court. They paid the amount loss. Because it was paid in 2018 loss, admitted fact loss. My writ application was dismissed, saying that I have approached this honorable court at a later stage, so I am not entitled to any interest. That is the finding of the Honorable Single Judge.
adopted by the states. I believe so.
But
That
we have
certain amounts
not
of
preferred the
claim
appeal.
that,
My lord.
the
He has
state
preferred the
government
appeal.
should not-
And he has preferred the appeal, but he has claimed after 11 years.
So
Why not that will be treated
why
as
you
a
paid
stale claim?
16,000? Why you paid 16,000? After 10 years, why you paid? That means you acknowledge that this is the amount which is due. He says, I do not want other amounts. I stick to the amount which you have paid, pay me interest. That's a very clear cut case. How can a writ petition be dismissed on the ground of delay and laches? And secondly, another question that we record. Can a government take a plea of limitation? Tell me.
Yes, kindly. Your Lordship may kindly appreciate the prayer made in the writ application that is on page 25. Your Lordship may kindly.
All the area dues, let us see, I'm not, please kindly consider. From a civil perspective, I always, a suit is filed for recovery of a money which is due to it. It appears that the suit is instituted after the period of limitation. The court will definitely see that whether the limitation applies or does not apply. In the meantime, when a pendency of the suit, the defendant comes forward and says that what he claims is not the full liability. I am admitting a liability to the extent of 16,000 and paying 16,000. If you acknowledge the liability, will it not relate back to the date of your obligation?
Provided it is a retirement benefit, my lord. Provided it is a retirement benefit. What
If
is the
you
claim
have-
in the
If
writ petition?
you have unreasonably withholding the money, which the incumbent is legally entitled to, will you not pay a compensation in the form of interest? Okay. You have unreasonably withhold that money. If you have not paid that amount, we would appreciate. Once you have paid that, on that amount you should. Not the rest of it.
Leave it to your lordship. But otherwise,
That is what I'm saying. He is recognized, this is accepted, he can accept.
he only claims area wages. Area wages, as per calculation during pendency of the writ petition, it was
Now got, so the plea of limitation will not arise. And he has abandoned his claim. So far as the rest amount is concerned.
Yes, I might specifically only interest. And 16.
Only on that amount which you acknowledge and pay. Look at so serious the counsel is, you have to meet.
Good enough, I know.
What to do? How much
although I have come prepared with the judgments on stale claim, but still, if my lord.
No doubt about it. Who says? Then I'm just saying, had you not paid, you could have appreciated. Why you went?
Even then also, my lord, he
Yes,
approached
improved
the
order
honorable
is-
court after a delay of more than 11 years, my lord.
Oh, we understand that.
Yes.
We are going to highlight that.
And no reason for delay was also explained in the writ petition. Those are all technical, but
With all humility, Lordship may kindly come to page 26.
2002 is the retirement. He approached
It's
the
not a
honorable court in
retirement, Lord.
2030.
Again, Lord, it's not a retirement.
Voluntary retirement. That is a,
Obviously.
it's a voluntary retirement.
And page
with
26,
acceptance
your Lordship may
of
kindly
all
look at.
the-
No, my friend is so serious. Please, your Lordship may kindly look at page 26. The date of disbursement of statutory dues shall be sanctioned by the state government and shall be paid to you in due course. That was in 2003. They did not pay it. Plus, I approached your Lordships. And during pendency of the writ petition, they filed a counter saying that in the year 2018-19, we have paid 16,000 only. Thereafter, Lords, I abandoned my duty claim. I said I may be paid the interest. And Honorable Singhal just said that no, because you have approached the court after 11 years, it's barred by Lords, grossly barred by Lords delay and lapses. So I will not sanction any interest. I never claimed any dues, Lords, only interest. And in the writ appeal, my only prayer is not for interest on 16,000 only. And what will be the interest on 16,000? Hardly maybe 20,000 Lords.
Look at what the litigant after getting this interest will take home.
I leave it to my lord.
What he will take home.
So the Lords may call it tomorrow, day after tomorrow, I will come with that document.
Tomorrow it's.
Yes, please.
With that judgment line.
Yes. No.
I will not search. Yes, go with it. Go. Keep this one.
Item 26.
I am going to play this matter will be taken up next week. Because this matter was extensively heard by my lord, sitting with my lord Justice Raman. Regarding that equivalency of the Sastri certificate to graduation. Your lordship had directed me to. Your lordship had directed.
Next week. My lord, Supreme Court already dismissed my lord.
Dismissed?
Yes, my lord. Lords, kindly have a glance. My friend is taking serious. Message remitted to Supreme Court. Supreme Court already dismissed. In this regard, state government filed the SLP before the Supreme Court.
Now what's the meaning? The court did not accept your.
The Smriti Rekha Mr. judgment. Lordship, kindly have a glance.
Smriti Rekha, after examining Smriti Rekha Mr. judgment, your lordship directed me to obtain the copy of the tribunal order, the High Court order, and the Supreme Court order, which I have come prepared with. And so also your lordship directed to get a copy of that 1979 notification by virtue of which the central government declared it as equivalent, whether it is applicable to the state government or not, whether the state government can adopt that or whether it has been adopted. Regarding that, your lordship had adjourned this matter to today. So that 79 notification I could not get, but next week.
Yes, your
that is
lordship.
why
Lordship.
Next week. In the prayer of the state.
Monday.
Item note 27.
I pray on Monday, man.
Yes, sir. Because Tuesday I am not available, that is why I claim Monday. I may be absent on Tuesday. That is why I claim Monday.
Which one? Earlier matter?
At the earlier matter, 36.
26.
Just one.
26.
Item 27.
I filed a miscase to delete the name of the petitioner. Don't want to proceed further.
Don't want to proceed?
It's number 3. Delete to name.
Petitioners are there. He wants deletion of petition number.
That is me fine now, but this is the thing that not what. What?
But in personal reason.
Personal vis-a-vis you.
It's none of other person.
The copy has not been given to me. I am only questioning over as to why it doesn't want to place that place.
You wanted a deletion of.
Deletion.
Right.
Where is the application?
File number 4471.
Like me. Keep up with.
Seeking. Writing now is from the category of the participants. As it does not intend to pursue the remedy any further. Since in party does not intend to pursue to advance, you do not find any better striking out this name from the category of the petitioner. We therefore allow the said application. The name of the petitioner, we delete it from the category of the petitioner. The rest of the petitioner shall be rearranged. In serial number by the department. Now you want to pursue, so there is 1, 2,
Next week.
At this juncture, the concept of the external movement in place for the.
Well, 28.
28, your lordship, there is a specific rule that I have to examine before receiving the mail.
In the orders, there is a 42 days.
Yes.
Those days they have filed the 2 days delays there.
How much?
42. So that is why I am saying I don't know seriously.
No, possibly be consenting. So
Your
now,
lordship, your lordship.
You are also call it some other day, condoning the delay.
this is an application for the position of delay of days.
In my lord, here state is the appellate. There is a delay of 5 years from the.
How many days delay?
30. He is required to file in updates. That has already been filed for instance of this. My friend.
Yes, I have got a copy. The delay of 131 days.
After I filed a contempt petition before your lordship and the state.
That's right. So this is according to you after CORAM.
I was only submit, sir.
Yes?
Yes, sir. I only submit. And the irony is,
Yes.
the order which the state government intends to challenge before your lordship. Pursuant to that order passed by the Honorable Secretary, a notification has been issued by the government regularizing such persons. To which category I belong, but leaving me aside.
Because you have
Yes, because
pursued the litigation.
because I have been protected by your lordship, sir. They just sidelined me, and from my line onwards,
So they
have
wanted the protection to be given by them, not by the court.
that is what my notes, their wisdom is. I cannot supplement.
Yes, it's a similar circumstance persons, you have notified them and regularized their services.
What may not been submitted, I'll have to examine.
That's a result, that's a notification, gazette notification.
What about the condition? You are not passing any immediate code.
That I leave it to your lordship's knowledge. State government normally beyond 100 days.
Will this take into consideration? Suryadeo's judgment is taken into consideration by you. Government, its instrumentality.
Yes. That judgment is always in all interview applications, then judge taking that apart. Our question, our prayer before the lordship is when the substantial question of fraud is there. Normally the unknown courts are lenient. Sorry, little bit.
That's lenient. That's true. You are correct.
Here they place only a fact only. There is no substantial question of law.
Brought those facts.
When
you brought those facts that during the pendency of this appeal, they have taken out the notification.
I have got 2 copies for your lordship's perusal. And that resolution passed by the government, ironically, just after the order passed by the Honorable Secretary Judge.
Okay.
9th of August 2024 meetings.
This subsequently, no notification, you can't.
It was not, just in the open court, I came to know about this. After my 11th submitted of your
officers should have given it.
18 special.
Do one thing, take instructions.
Yes,
Not
that's what I.
passing any order.
That's what I said.
Let us see your client's stand on that. Consequences. Because if we take into consideration, then you have no merit.
I understood.
Camera.
Fixes a date.
That's
Not this.
30th July. Item 30.
I will serve it not place.
Give them a copy.
I will mail it.
That notification, resolution.
That is normally the habit of this. It is our habit.
Give
We'll give it.
Give one copy. Give one copy. No, here.
Yes, madam.
Yes.
I am giving. I will substitute other copies for your lordship's post.
Brother has noticed is the cabinet decision. You are done. And fighting in the court.
Certainly, my examination, certainly I will.
It is after the impugned order was passed. Now, immediately within 1 month, this decision has been taken.
Yes.
And the
We are
secretary
filing an appeal. That is what.
Certainly, I will be fair in my submission after I take my position. I will be fair in this.
Item number 30.
Yes, sir. 30, again, my lord, there is a delay of 125 days.
The
notice is no Nobody.
But
Nobody has appeared, that is why. Now, my so I answering, if not you have instructions to appear, I can give a copy.
What is the good name?
A. Satpathy, your lordship.
A. Satpathy appears. And
But is that supposed to appear because in the difficulty of paper, some of it.
we are on in this. And the pretext of this writ appeal, in the interim order, there was an order that those employees were working and continuously working, and from November onwards, they have not been paid the salary. So Honorable Singhal just said, without prejudice to the contentions of the parties in the pending writ petition, you should go on paying them the salary. They have stopped paying. We filed a contempt also, that is also pending. And on the pretext of this writ appeal, they have been trying to delay the process. We are granting him a time in the writers, but it will not prevent the other. The Honorable Singhal has to take it on importance. No, absolutely. No difficulties. When he want?
Next week.
Next week. Are you sure? Next Wednesday. Then we are keeping it on the prayer of the predecessor. Not a copy.
Speak to my lord. The first matter. Speak to my lord, there are two writ petitions in the writ appeal. The first one that was filed by, there is no delay. But in the second one, sorry. In the first one, there has been a delay of 507 days. My learned senior has given a reply. Hence,
I invite objection.
Both of them have challenged the same one. Suppose if this repetition is dispelled, does it impact their appeal? Both. If the judgment is ultimately found to be illegal or erroneous, then the appellate court, if it's set aside, then it will ultimately resort to its benefit. So it is better when his appeal is within time. If the court is bound to hear out.
Yes, ma'am.
Against the self-same order, if he has filed an appeal, then what is the difficulty?
But my lords, I have a prayer also. I have a prayer. Writ appeal number 500 of 2016
arising out of the same order, which was dismissed earlier, and CMPL was filed to 209 of 23, that was restored back on 11th of December 2024. That writ appeal may be tagged along with that, because again, same matter. My lord,
Who has filed that writ appeal?
my lord, one of the teacher has filed, Gitanjali Jagdev has filed, relating to same issue, my lord.
No. Against the same order?
No. My lord, that is challenged by the order of that Justice Rathor's order. Yes, separate
order. It is the common order or it is a separate order?
But it relates to the same thing, man.
Oh, maybe the point of law or that it is same. But it does not mean that it has to be heard. We just wanted here that the application for condonation is to be allowed or should not be allowed.
This order today for the condonation be ordered.
That's all. So we are thinking of when their appeals are also here, there is no point of
in the condonation.
Yes. There is no scintilla of doubt that there has been an enormous delay in filing the instant appeal by the state of Orissa.
Sir,
You have to pay.
Week after next.
Pay that up.
Week after next.
4th August.
4th August. 4th August, you have a problem?
yes, some problem. My lords may have become 12th of August.
August.
Or I think after that, because she has some problem.
12th August. Item 33.
Yes.
Second matter, I appeal 27. There has been filed initial delay is there, but in my petition, the copy has been served, no IA. No IA for condemnation of delay. I know 206. So like, but it was not served the copy on him.
As the copy of the application for presidential is also served upon the president director to serve the copy of the said application in course of this day. Matters is listed.
Item 34.
But there is delay. 121. Yes. Then last is more considerate. Was more reasonable.
And this common. Here, my lord, if your lordship takes up this matter next week, not even going to the question of delay, the matter has already been taken up by the High Court. But I gathered from the, actually, as a matter of fact, I don't have any documents with me.
I brought my lord. No, I cannot get it. What you say?
The matter is, my lord, the common judgment was passed by the Lord at single judgment. 10 writ applications were disposed. Out of which 4 writ appeals were allowed by your lordships from the same company.
So this will receive the same. So we condone the delay.
That's what I'm saying. But I think
Some day after tomorrow. Just go through it. Because common judgment.
Yes,
is already allowed.
That's that will cover.
My lord, this is the judgment, my lord, I supply.
Lordship.
Main judgment, my lord, 119. Then receive the analogous order.
There's you have gone up.
I go to it.
You say it should come out to. Better, sir. Day after the. Day after.
Copy be kept record.
Yes, sir. Item note 35.
These 2 items, my lord, have been filed by Odisha State Legal Services Authority, and I'm appearing for them. It's a PIL. The first one, my lord, 15808, is for rights of construction workers. The workers who are engaged by builders, construction workers. So this case has been filed with welfare benefits which accrues to them. My lord, the peculiarity of these workers is that they pay the builders pay stress for the workers. Second is that the workers themselves, my lords, pay 20 rupees each for registration and 50 rupees thereafter to the board.
Monthly.
So my lord.
Monthly or daily?
No, on engagement.
On engagement.
My lord, my anxiety in this case is that I would like to take your lordship to order dated 19/1/03. 23, my lord. Order number 9. The next page of the order, paragraph 4, my lord. Since waiting for the petitioner has placed a note before the court in which, after analyzing the figures provided by the state government in its affidavit, she points out that by the end of December 22, a balance of 579 crores remains unutilized by us.
This is not disputed by the learned additional standing counsel for the state. So this money is purportedly for the people, for the benefit of the workers.
This money came from there, from the state.
From the cess?
I think the largely or from the central.
No, from the state, my lords. Not from the state. It is from the builders.
It's an allocated budget, budgetary allocation.
There is no budgetary allocation. This is all money of the builders and the workers themselves. So they are supposed to answer to this query, for which they have taken time twice, I think.
What is the Supreme Court, the election, the National Campaign Committee for the Central Legislation of Construction?
Yes, madam. That I have pointed out to show that the figures that they represent their annexure therein did not tally with the figures that they had submitted in their affidavit before the High Court.
Yeah, what this?
There are lot of criticism to the state on that. My lord, this discrepancy is in annexure to their affidavit. So this is what they have to answer to the state and the people.
There was a direction that the state government will have a special audit for all the amounts.
Yes,
that and disbursed
yes,
under the Creation of the Act within 6 months. The only parties can ensure the separate accounting of the accounts collected from 3 government. That has to be done. Board will also file an affidavit with the provision. What is that? Have they done? Is compliance. Thereafter, twice the matter appeared.
They filed an affidavit in 18/12/23 by the director of local fund audit, where they say that they're on time for the special audit to take place because a lot of documents.
More than 1 year has elapsed. The last order was on 18/12. Have they conducted or completed the audit?
As a matter of fact, on 29th of January.
Goes to you. No.
29th of January 2024, we have filed an affidavit enclosing there is the final special audit report. 29th January of 2024.
I will give him a copy to her.
Actually, my records show it has been filed through mail. First, they are when 29th of January 2024. 29th January 2024. Mail.
My lord, if I may say so, my lord, the report starts with only annexures. So what is the essence of the whole report?
No.
Only annexes are there.
No, it starts with annexes. There's no index or nothing to show the annex.
Acha.
Probably a day.
No, there's not. There is. No question of anything. That's a report from page 6.
Well, they're given another.
First 3 pages it was missing.
Oh. Because it ran over several pages.
Over 146 pages.
Report is there. What is it? They're written. With what audit? Yes. What do you want? You have been served. Is it, you'll have to show that.
I might need another set of audit to look into this bulky. But only that in that affidavit, they say that the audit report has observed that there are some irregularities in funds at district level due to. So the irregularities.
Has to be taken in very often.
Yes.
These two.
Yes, ma'am. Certainly.
Because this is an amount to be utilized for the welfare
Payment
of
of
the construction workers.
Yes, ma'am.
But if a 10 days time may be given from the.
It's 19/1/2023. The audit report did not see the light of the day. So far as the petitioner of the instant verification.
The other matter which is tagged with this is different, my lord. Now, it is about unorganized workers, but it has been tagged because they are workers probably. In this case, my lord, um, again, the State Legal Services Authority has filed this for effective and purposeful enforcement of the statutory benefits to be granted to the poor unorganized workers. Well, the development in this case is that, as per the order of the court, the chief secretary had conducted a meeting of all the stakeholders, and thereafter the proceedings have been filed. But now the situation as to how far they have progressed as per the decision made during the meeting.
The when that meeting was,
The meeting was on 20th April 23,
20th April 2023, now nearly 2 years.
and they filed it in court on 24 January 2023.
I find this under the district, after 23. What is that?
About this case, actually.
The meeting was held, what is the outcome of the meeting? Pursuant to the order dated 21/3/2023. The
officers from various welfare departments, and thereafter
What is to be done?
the data is most important, my lords, in this.
No, the collection of data definitely involved. You need an empirical data to understand that how it works. But that is the one issue. As you said, that is very important one, how to spread the awareness among those sectors. And who will take the task of this? Is the state legal services authorities also responsible for spreading those schemes and the benefit by holding lot of seminars and awareness camp?
That meeting also.
What you are doing?
The meeting has also referred to district legal services authority.
That's why I'm saying what you are doing. Have you already assigned those instructions to your DLSA? That you go and make some seminar, take a camp, let the people be aware. It is both the collective duties of both the SLSA as well as the government. So why don't you act in tandem? Do not pass on the buck. So do one thing, you come, both of you come with the modalities.
Yes.
And how this has to be streamlined. So that a synergy is created amongst the DLS, SLSA and the government.
Yes.
And the area specific has to be identified. So this report should come from you, giving a suggestion. Will accept. And the election one is not included, that what are those 50 categories?
Yes, ma'am. Says.
It says so, I have seen, but election one does not, is not included. Immediately the notification is included. Please come to that letter. At phase 9 of their affidavit, and thereafter they just include that letter from the labor commission. That's all. What are that 50 categories is not given? As per election. E. Election is not included. We wanted a election.
Disclosing everything and
Otherwise, we will contact this because to read this requirement.
disclosing everything and
How to create the awareness? Yes. How this to become. What are identify? First thing is identify. The whole area where there are asked a lot of unorganized. Okay. Give us a suggestion. We are keeping this matter after 4 days. Taken or likely to be taken.
short issue that is here before my last purpose.
What issue?
Yes,
What is that?
the petitioner was having a license to run on shop. Since
On shop?
On shop. Since 2009. It's in the rural area. But shop was being operated. State of Tamil Nadu versus K-Bank. 2016. 15/12/2016 the threat came. Along Supreme Court said that within 500 instances made a discuss all the shops we know when coming policy later on it was modified as revised on 2 dates 11/11/17 23/2/2018 and 22. 2 dates it is revised. Now pursuant to the original order it is reduced from 500 meters so far as the rural areas are concerned. So Supreme Court left it to the state government to upgrade policy. In our state, it is 220 meters. Government has framed the rules to 220 meters. Now here what has happened is, pursuant to the order passed by the Supreme Court, from 31/3/2017, the license which I was running since 2009, they stopped renewal and closed this. But that is the outcome of Supreme Court judgment. Nobody can do anything about. So shop remained closed. Renewal they did not allow. Now thereafter, they granted liberty to the licensees that you apply for shifting of your shop because they are interested for revenue. So 5 times this petitioner applied for different locations to shift the shop till the last order was passed by this Honorable Court by which it was set at rest. Government said the last application which I have filed for shifting, that is plot number 919. Now we will consider that, we will allow shifting, we will relax that one restriction under Rule 26, subject to, if Lordship will see, the petitioner pays the whole license fee from 17 to 20. 18 to 20. That's the point. And section 35 says it is only against a license. Nothing fees or duty, whatever is, against a license. And you have stopped it, you have stopped renewal.
And the sides.
No. Yes, there must be some reasonability. First thing is that they say that they were operating on shop like basically on shop function, liquor shop. After obtaining a license, now there was a judgment of the Supreme Court which rather creates a pressure in them in running, and you can stop. If continue. Now they have been saying that yes, now it comes within that particular distance now. You can't operate, you have stopped it. I wanted to shift it to another. Then a shifting order is done. And then you were sitting over the matter for a pretty long time.
No, Your Lordship, on 5 occasions, they gave sites which were not suitable. Law and order situation was there, the Superior Police report was there.
Thank you.
Now, yes, Your
They
Lordship.
say that, you say that yes, it is a site, there is no problem. Then the license which we issue is have a retrospective effect for a possibility.
Not renewed, Your Lordship. It is a continuous process. Every year the license is renewed, Your Lordship. For 5 years initially it is given.
How can you renew in derogation or in violation of the Supreme Court order?
Your Lordship, because of the Supreme Court order, they were asked.
The Supreme Court says that there cannot be any liquor shop within that particular distance.
Yes, Your Lordship.
Then in that event, how can you renew the license? That means you are acting
No,
in
Your
violation
Lordship.
of your
No,
order.
Your Lordship, they have to shift.
Madam,
They have to shift.
Why?
They have to shift.
If they do not want to shift,
They wanted to shift, so they're given 5 proposals, Your Lordship.
I think Madam Patnaik, it will not be required to show about that. Kindly see page 78. Government as a holistic measure has taken a decision that for these kinds of shops, those licenses, even if deposited, they will refund it. Kindly see that order. Page 78, 2011, 17. For these kinds, annexure 18. For these kinds of shops, even the licenses who have deposited, they will refund. And there are judgments, I'll cite me not.
shops closed on account of the reasons not attributable to licensee, he is not able to pay.
Absolutely, that is what I'm.
There are two judgments, my lord, I
I
can
was
say.
thinking on that.
Right? Kindly similar these two judgments, so Suresh Chandra Misra and the other one.
And this is what is there. Yes. That's your decision.
But the lordship, they find a suitable place, that is the onus of the petitioner. Five consecutive applications were for places which it was not feasible because of law and order situation, your lordship.
You are not understanding what is passing in our. Please try to understand.
It was a closure pursuant to the.
Now I think it. I'll give you. A license is issued at a particular site for a period of. He did not, he operated that shops. During the period of 1 year, the period the Supreme Court has said that they can. They did not require the order of the basis there. You have said that it's not. Now it attracts two things. One is that what about his liability to live minimum guarantee with quantity which he is supposed to live within a period of 1 year. Whereas you have stopped his operation within 6 months. Then what would happen? Are you entitled to claim any excise for rest of the period for which you have stopped him to operate? Stopping was that he cannot carry on his business. Now what he says that then you say that whose shop comes within that, may I use the expression, mischief of the Supreme Court judge. If they want, they can shift to another.
It's a new license, not new.
But bottom line of the story is that they are prevented by your order to operate. It was an additional, I would say, a succor which was given by a government to those persons who cannot operate. They exercise that power. Now you sat over it for a pretty long time. You raising an objection, this side, is near the educational institution. This side, is near the religious, the place. All these you did, and ultimately they say that yes, no, I can't. Suppose if it takes 5 years of now you permit the schedule.
So all the owners rely on the
Will
state.
you charge for the whole of that 5 years? And he cannot operate from the existing side. And an additional right of shifting was provided by, otherwise he had no right of shifting. His matter comes within the mischief, gone, license cannot be charged for the rest of the period.
Your lordship, all the losses will be incurred by the state because he's given 5 sites which were not according to the statutory.
I could have said that Indian is the site where there is no problem, even affidavit, and then if you are the adjudicatory order, if you think that this site is not available, then why they should be finalized?
Because of your lordship, the sites, as per statutory laws, the sites were not the appropriate sites. So it is not within the prerogative of the excise authorities, your lordship.
The objection of the villagers are taken as the paramount one. I have not seen anywhere in the excise rules.
Here also there is objection. They are ready to relax it.
Only here I find. There the authorities have their freedom. These norms are always there. That has to be adhered very strictly. Religious places, the educational institutions, the hospitals. Yeah, let's Effect of Article 2 is the medical shop. Encourage. Well, one should not have to travel.
We have a de-addiction policy here. In fact, it's out of court, the de-addiction matter, I have given a thesis to the government. I was appointed as the amicus curiae by one of the solution. De-addiction simultaneously, what is the amount you are spending for de-addiction of these people who are taking it? What are the measures you are taking? What is the treatment you are providing them? All these things are also state's duty, Article 47.
That's the direct principles, is the law
Yes,
which has to be done.
yes.
Yeah, it's a test of reasonability we are thinking. You have to pass a muster of the mandatory principle. How can you accept this? There must be some rationality, some reasonability. What are you doing?
Lordship, all the owners' losses will be on the state's exchequer, and we will not face any losses for not finding a site that's suitable.
I will dictate to order the staff of the consent. No reasonable man would accept this proposition.
Right, yes. Because the lordship is supposed to get a site that was unobjectionable. So once you would have got a site that was just and proper, his license would have continued, your lordship. 5 occasions they found sites which were not suitable.
Not get where I'm giving now the more rudimentary or elementary. Suppose you have said that your shop comes within that particular distance comes of each. You say you not operate. We did not apply for any charge or a shift. Any charge. He said, I am not going to ship. I do not want, I will go. So people order is there. Shut the door. I do not charge.
But here he wanted to shift.
I am again saying, then I am saying that is on a parameter. If it does not, then he cannot, because there was a compulsion. It's happening is somebody who is already operating. If he wanted to shift, then he voluntarily applied. There is no inhibition, there is no prohibition, there is no better. But he wanted to shift. It may be that the business here is not so lucrative, which the business, or here the detoxification has come in that particular area. So they wanted some other place to get toxic. So in that event, you can say no different. But here they have no role to play. Their hands are they do not want to shift. They were happy. But it is that compulsion that comes. So how they should be saddled with the please consider in that perspective. We are thinking in that perspective. It's not a voluntary act. And the government has a for his own wrong. And which is the place where the
Judgments will not should be seen. First judgment, I was Suresh Chandra Misra versus State of Odisha, para 7 and 8. Another important fact, sorry, I'm so sorry. Convert judgment also not Krishna Chandra sir, the next judgment. Narayana. Krishna Chandra sir, Suresh Chandra Mishra is referred to you. Narayana. Narayan Prasad says, I'm sorry. State of Odisha was Narayan Prasad. Narayana. Krishna Chandra sir was state of Odisha. Recording.
Amendment which happened in the Mining Act, section 8A was introduced, by which Lordships would look at the central legislation. The Mines and Minerals Development Regulation Act, 1957. Lordships, 8A was introduced. And we are basically claiming that we fall under the benefit of 8A5. But they gave us 8A6, even though we protested. I'll explain the difference, Your Lordships. What happens is, prior to coming of this amendment, there were various leases which were there either on a renewal stage or they were the first grant. So what the central government did, that if you are a captive consumption, that is on the date of coming of this amendment, then your lease shall be deemed to be renewed and renewed up to 31st March 2030. And if you are not under a captive consumption, then it is 31st March 2020.
10 years difference.
Yes, sir. Because of the captive consumption issue. Now, Your Lordships, basically, my mines is a China clay. Now, Your Lordships, China clay is that which we use while we make our cups. And yes, and Your Lordships, it has some use in plastic industries, in paints, but basically, the captive consumption of such a mineral would mean its beneficiation plant. I had a lease. Your Lordships, may I take Your Lordships to the small date chart we have filed? That's showing also in Your Lordships.
Where is the date chart?
There must be a written note from date chart, something like this.
Yes. There's a copy. Sorry.
It is showing.
Flagged? It's flagged as written note.
First, the first, just right under the index.
Second page of the page. Okay.
Yes.
Just under the synopsis.
Yes. Under the heading index.
Second page of the page. Second page of the page.
This is page 2 of the PDF. We can see it on this screen. Hard copies also.
Anyhow, you just start what you have, what you are looking at. Tell me from there.
In 1966, this lease was granted for 20 years.
You want it, so this, you have given it.
Yes, Your Lordship. Lease was granted. Now just.
1966. Your father was granted a mining lease.
Yes.
Okay.
And Your Lordship, these leases are all granted in Form K. They are statutory Form Ks. And it at clause 8, it said that I can do beneficiation of this mineral. there is nothing called as a captive form K or a non-captive form K lease deed. It doesn't say anything like that. We'll show those statutory forms. Thereafter, Your Lordship, there was a renewal of 10 years. And then, Your Lordship, there was.
It was initially for 20 years.
Yes.
Thereafter, in 1996.
It's 1986.
It was for 10 years.
10 years. Yes. And then, Your Lordship, I did make another application for third renewal in Form J.
On what date?
Your Lordship, the renewal application was made on 20th 9, 1995. 9.
Yes, 1995.
Right. That's there under Annex 2, page 62 of the.
Yes.
And I had disclosed that I'm going to use it completely in my beneficiation plan, which I have already set up and posted. Yes. I was granted that on April 2000. I was granted that somewhere in 11/3/2003. With effect from 14/9/1996.
Yes. 14/9?
1996.
15/9 you have written.
Yes.
Okay.
Now, Your Lordships, this
was up to 14/9/2016.
16.
Then?
So, Your Lordships, the last year again, I had to, before I could make a renewal application, that's when this amendment comes. So, we did not make a renewal application. We went into that, the deemed extension. But, Your Lordships, when this came on 12/1/2015.
This act was introduced.
12/1/2015. 12/1/2015.
And the lease was live till
for 14/9/2016.
16. So at that point of time, it was
alive. And Your Lordships, what happens is, on after 12/1/2000, on 10th, Your Lordship, yes, on 10/2/2015, a notification comes whereby I'm removed from a major mineral and I become a minor mineral.
just the reverse. The person against majority from the minority and you
Exactly.
put back from
Yes.
majority to a minority.
Yes. And at that time, in state of Odisha, you had the 2004 rules. The Odisha mineral mine. Lordships, obviously the bell rang. Now I'll have to make a renewal application because now I'm coming under the Odisha mineral minor rules. Otherwise, I had a deemed extension, so now I have to make it. So I did make, and I also sent a letter to them that please extend the same 8A benefit. The government sat over it, even though there was a legislative vacuum then, but the government did consider for all the leases in Odisha who had become a minor mineral that we shall also grant you that. Because, Your Lordship, the similar kind of amendment was also in process to happen in the local law. Yes. So, Your Lordship, but instead of giving me till 2030, they gave me 2020. I made a series of representation. I signed that supplementary lease agreement under protest. That's all there. It's an admitted case from both sides. And Your Lordships, then the new rules come in, which is the 2016 rules, which had a provision, transitory provision, saying that the benefits of Section 8A will also be granted to
Minor mineral.
Yes, Your Lordship.
From a retrospective effect, from a prospective one.
Retrospective effect. Your Lordships, I'll go through the language.
Then
Your Lordships, at that stage also, I was already pressing with the government. And the government was considering that, yes, probably you should have been given till 2030 instead of 2020. All documents are on record. But Your Lordships, they refused to give me the benefits saying this, only this, that your lease deed does not say it is captive. Even though they made that entire inquiry and found out that not a single piece of my mineral goes outside, but everything is used in my captive plant. All those things are there on record. Now, I say this is something which 8A did not allowed.
And this concept of captive mines or something that originates, what is the genesis of that?
Your Lordship, the genesis is few provisions.
Because your lease to be ensured from 1966.
Yes, Your Lordship.
And it is on the same terms and conditions, it is being renewed.
Yes, Your
It is-
Yes. On same terms and conditions.
Everything is stipulated there.
In form case, a statutory form. The statutory form also does not have any captive consumption clause.
When this captive concept started.
No, that's in the major mineral rules. Your Lordship, that I'll have to. I'll consider that I do not, that historical fact I'll have to look. I do know.
About when you're taking all those these are very relevant when it came.
Your Lordships, I don't disagree on that. I say I am captive.
No, because your original lease, which was executed way back in 1966. And then the renewal that took place. And the renewal has taken place on the same terms and conditions except the duration. Duration remains different, 10 years, sometimes 20 years or whatever. Now, when the captive user sunset grants, then according to you that has to be incorporated. If they are not incorporated.
No, I don't say that it has been incorporated.
According to them, it has to be incorporated. If the original deed does not contain that, but the intention is that you are using it for your own consumption. And there is not a single iota piece of paper which they have brought that you have taken even a minuscule part of it outside it.
Yes.
For some gains. Then in that event, the intention or a dominant intention has to be considered or gathered from those facts. For that reasons, you have to bring it.
Yes, Your
The
Lordship.
last renewal.
I in fact was expecting this question, but in a different way. The section 4 which stands today also, and which stood earlier also stands today, which says that nobody shall mine without a mining lease, does not have a concept of what they say is that a merchant mining lease and a captive mining lease. So this is something they coined while rejecting my prayer. But in the statute, the section 4, your Lordship will see, does not have, till date does not have that concept. Till date does not have that concept. And Form K, which is a statutory form, we've gone through it. I've gone through the old 1960 regulation rules also, under which this Form K was there. Till date does not have that distinction. Your Lordships will look at the language of 8A. The language of 8A is used. That means on the date of the amendment, it is de facto used. Even if you write it, your Lordships, we file monthly and annual returns. Any mine holder has to file monthly annual returns, in which a person can clearly make out what is the consumption pattern. That was also examined. So if the de facto use is captive, then you are under this. That's the language, your Lordships.
Why do you say de facto?
Your Lordships, may I just...
Specie.
Because the language
It should be an ex specie. Why de facto? De facto is a different concept. De facto and a de jure are the two concepts.
Fact, what I mean is that actual use.
Ex specie.
Yes, your Lordship. I would hold. Actual use. You know, the language is this. Notwithstanding anything in subsection. Your Lordships, I have the Honorable AG opposing me this time.
Honorable AG doesn't oppose. My duty is to state the law. I am either representing this side or that side.
Just 1 minute.
Please don't use the word oppose.
He will never personally oppose, but he will oppose your client.
Yes, so that's
I never oppose anybody, my lord, except addressing on the question of law. I do not do that job personally speaking about myself. Anyway, my lord,
So it's an
she has a very poor case.
She has
Therefore,
flagged a
she is-
very interesting question. So
everything
we wanted to hear is a pure question.
But
of
it is
law that
quite
would
non-interesting.
Yes,
I'll explain your article within 5 minutes. It's quite non-interesting. She has a very poor case, so
We
therefore.
want always an
That's
interest to
correct.
gather.
So that is, Sure, let your lordship here, it's already covered by two earlier division bench judgments of your lordship.
Your Lordships, I
Let
know
her address.
it is,
You know the etiquette that when AG addresses, it should say.
That's-
Let her address.
blanket statement stated. I know you lost it there.
We are already ahead of that.
Lordship, I am only,
When we were AG here, we wanted that, what would be the convenient day so that we can fix this matter and hear out this matter extensively.
can I come tomorrow, Your
Definitely we
Lordship?
find the
Tomorrow.
starting points to ponder upon. It may not be so good, it may not be so relevant, but at least we wanted to hear both of you to tell me the date.
Your
the
Lordship,
time,
I
when,
would
you
say
are able to
tomorrow.
speak. We wanted to.
I'm badly placed.
It is-
For this entire week, period, I'm already occupied. Let it come any day in the first.
So
week
you
of-
suggest a
There is
date.
no hurry. Lease has already expired since 31st March 2020 by operation of law. C intends to have 10 years more.
Your suitable date, you just. tell me
Any day in the first week of August, because
Any day
next
you
2
just
weeks
tell
I'll be
me,
busy.
which, can we fix it on 4, 5,
Not
6,
date exactly,
7?
that is what.
Fourth,
Let
fourth.
it be on 4th as per her.
I have a reason of the inquiry.
Just it's.
Patience, be patient. Yes.
But my schedule has become very fluctuating because I do not know at which place. Week commencing from this, any day that would be convenient to your lordship.
So we are fixing on 4th, that will be a first day, no difficulty.
Monday, it should be on a Tuesday there. Monday is a miscellaneous day, I'm appearing in a number of matters.
Outside, it's a SSB day.
That's what.
Is it miscellaneous, non-miscellaneous and miscellaneous will be on.
No, that's correct. For every day your lordship is done.
Friday and Monday is the SSB.
So that is why I am submitting. Monday would be difficult for me. I am appearing in a number of matters in suits.
Next case. So, come on, Phil.
Lordship, if you can come on the top of the list if you're because the only problem is, I'm a little apprehensive, the years I have lost in litigation, I don't know how I will.
Has already lapsed.
2020
has already lapsed.
There was nothing which happened in the matter. These matters, now this bench has decided to list it. Then at least give some spite to the bench also.
Yeah, I agree on this. I agree.
Your Lordship had asked me to remind your Lordship that item 54.
Yes. Who is appearing for the?
In this case, today we are filing affidavit. Today I am serving copy on him.
I have 5 minutes.
We are fixing this matter tomorrow as a first one.
My item
Tomorrow as a.
item 43, my lord.
No.
Next.